Good afternoon, everyone. Hope everyone is able to hear us clearly.
Yes, we can.
Okay. A very warm welcome to all our attendees and our esteemed speakers. We are truly privileged to have you here with us today for this exciting and informative webinar on navigating the dispute resolution in Asia, the trends, challenges, and practical solutions. In an increasingly globalized world where business operations transcend borders, how do we ensure that dispute resolution mechanism remains effective, fair, and accessible across diverse legal system and culture? We will get the answers as we move on ahead with our webinar. The goal of dispute resolution is not only to settle conflicts, but also to turn them into chances for growth and better understanding between the parties. Hello, my name is Saloni Kataria, and it's my absolute pleasure to be a moderator for today's session. We have a truly exciting agenda lined up, and I'm thrilled to guide you through what promised to be fascinating and engaging discussion enlightened by our panel of experts. This webinar is designed to provide you with valuable insights into the evolving landscape of dispute resolution in Asia. We'll be diving deep into key religion trends and emerging challenges companies face in cross-border disputes. And most importantly, we'll explore practical solutions for navigating these complexities. This webinar has been organized by WithLaw, a leading full-service law firm recognized for its expertise in providing innovative legal solutions across a broad range of industries. We have expertise in areas such as dispute resolution, finance and investment, energy and environment, with a particular focus on emerging technologies including artificial intelligence, blockchain, and ESG. Witlaw has made a significant contribution to a global legal framework, including those issued by UNESCO, European Banking Authority, SEBI, and International Financial Services Center Authority. By aligning with global framework, we manage risk and contribute to policy development and innovation. Moving ahead, we are also honored to have our supporting partners, Mumbai Center of International Arbitration, which is India's leading international arbitration institution, offering a neutral and independent platform for resolving commercial dispute. It has significantly enhanced India's position as a hub for international arbitration. Another our supporters are Asia Pacific Center of Arbitration and Mediation, is an international alternative dispute resolution center formed jointly by the centers from various Asia and Pacific countries. It facilitates the resolution of international and cross-border business disputes through a unified set of mediation and arbitration rules, promoting efficiency and consistency across the region. Moving to our last supporters, Asia Pacific International Arbitration Chamber, which serves as a leading institution for arbitration and mediation in Asia Pacific region, providing a platform for resolving disputes. Its commitment to excellence in dispute resolution services has been pivotal in fostering a conducive environment for international business, and without their support, this webinar would not have been engaging. Let's move on to our panel of experts, and I'm extremely excited to introduce our distinguished panel of experts from India, Thailand, Singapore, Malaysia, Cambodia, and Hong Kong, who will share their invaluable insight with us today. Each speaker brings a wealth of experience from their respective countries, providing us with a truly comprehensive view of dispute resolution practices across Asia. Mr. Swar from India is a founding partner at WithLaw, specializing in policy and regulation. He has led mediations and reviewed various frameworks for organizations like European Banking Authority, UNESCO, SEBI, and International Financial Services Centers Authority. As experienced arbitrator, he has judged in events like FDI Moot, AIAC, APAC Pre-Moot, and ICCA. Dr. Vanina from Thailand, she is a partner at Raja and Tana Asia, is an expert in international arbitration and investor state dispute settlement with an extensive experience as counsel across various jurisdictions. She chairs the Chartered Institute of Arbitrators Thailand and is a former ICC court member. Mr. Aziz from Singapore. He is in his legal practice since 1967. He has been active in litigation and alternative dispute resolution, including mediation and arbitration. He has served on the panels of various arbitration institutions such as Appeal Committee and Chair of Club Licensing Appeal Body. Moving ahead, we have Mr. Izzat from Malaysia, specializing in civil litigation with a focus on corporate and commercial disputes. He represents clients in mediation and adjudication under Construction Industry Payment and Adjudication Act 2012 and is very passionate about alternative dispute resolution. He has judged competitions including Viz East Moot and AIAC Pre-Moot. Further, we have Mr. Djamel from Cambodia is registered as an arbitrator and mediator with an institute such as NCAC, THAC, BICM, MIAC, and AIAC. He has also taken advocacy and leadership roles as Secretary General of the Chamber of Commerce and Industry France Cambodia and Chairman of Europe Chambers of Cambodia's Human Resource Committee. And our final speaker for today is Mr. Lavesh from Hong Kong. He is a barrister at Prince Chamber and specializes in commercial, construction, and corporate insolvency. He is a member of Hong Kong 45 Committee of Hong Kong International Arbitration Center and a former committee member of the Chartered Institute of Arbitrators East Asia and Young Member Group. Before we begin with our webinar, I would like to extend a special thank you to all the attendees joining us today. Your curiosity and enthusiasm make this event truly valuable. We encourage you to engage actively throughout the session and please feel free to share your thoughts and questions and we'll address as many possible during the Q&A. Additionally, I would like to inform all our attendees that certificate of attendance will be provided only to registered attendees who stay for at least 100 minutes. These certificates will be available until 31st of December 2024. The issuance of certificate of attendance is at the management's discretion. Please join with the email used for the webinar registrations. And also, the WhatsApp group for the future events and updates is also the link for it is been shared in the Q&A and it has been requested to join our WhatsApp group for that. Thank you once again for being here. To give a brief overview for today's session, our esteemed speakers will be presenting in the following order. We'll begin with Mr. Swar from India, followed by Dr. Vanina from Thailand, Mr. Aziz from Singapore, Mr. Izzat from Malaysia, Mr. Djamel from Cambodia, and Mr. Lavesh from Hong Kong. We are excited to hear from each of them and gain an insight from their diverse expertise. Over to you, Mr. Swar, and let's begin our webinar.
It's a huge introduction. I welcome all the panel of experts for this webinar. We are overwhelmed for your presence and all the attendees. As you all know that we will be covering various jurisdictions. I have been bestowed upon to present the Indian jurisdictions. Let me start with the presentations. Please bear with me for a minute. Welcome everyone. This is Swar Kansagra, co-founder at Withlow. I will be presenting the jurisdictions of India, followed by various other prominent Asian jurisdictions. So let's just focus how India is evolving in terms of cross-border jurisdiction. So we have, first of all, the Indian jurisdictions have various level of courts, where we have the Supreme Court at the apex court, which is at the top of the judiciary. Below that, we have high courts, and below that, we have district courts and taluka courts, which are lower courts. Apart from judicial systems, we have various arbitration centers, namely Mumbai Center of International Arbitration, Delhi International Arbitration Center, Indian Council of Arbitration, and we have also mediation centers like National Mediation and Conciliation Center, and also we have a state level mediation centers, which are again catered by judicial bodies. So we have a blend of bodies where some prominent bodies are acting as an individual ADR bodies, and we have also judicial and the government supports for various mediation centers that are being run at the state level. Now, how India is placed when it comes to cross-border disputes. India has promoted foreign direct investment and has introduced various special economic zones and have been successful in attracting FDIs because of SEZs. And more importantly, India is now promoting GIFT City, which is International Financial Corporation, for attracting various financial bodies internationally to invest in India. And more prominently, recently, the aircraft and maritime ship leasing market is being developing in the Indian market because of IFSCA. The second global trend is FTAs. Trade envisions we have been resolving the disputes internationally, which are the principles that we follow are guided by various international frameworks. This judicial system that India is following is as a result of various treaties that India has. Some of the treaties are Singapore Convention on International Treaties. Also, we have New York and Geneva Conventions, which we follow. The disputes that we have the hierarchy of the lowest is the civil judge, and then the above is the district and sessions judge. Above that is high courts and high court judges and Supreme Court judges. The challenges that we face when it comes to the litigation frameworks in India is that due to multiple ways of dispute, probably my friends will also highlight such kind of challenges. But in India, what we specifically focus is that we reduce the time of dispute between the parties, which is one of the biggest challenges when it comes to proceedings. Because you may know that the arbitral award may be challenged in various judicial bodies. So this is one of the challenges that is an Indian jurisdiction we are facing. Overview of ADR market in India. We have various bodies like MCIA, DIAC, IAMC, and ICA. And recently, corporates in India are focusing on mediation specifically because they see this as a time-saving and cost-saving procedures. And therefore, we have been come up with various mediation centers. We are supported by government itself. Now, when it comes to challenges and opportunities in cross-border dispute resolutions, uh, we try to follow the New York and Singapore conventions, which promotes uniform enforcement standards. Apart from that, we also have an gel with New York Convention on Mediation, Hague Convention on Foreign Judgments, of course, for the International Court of Justice and Permanent Court of Arbitrations. So let me figure it out. India has been one of the slow pacemaker when it comes to the ADR field, but we are, as in India, we are focusing on challenging or we are resolving the challenges that we are facing when it comes to ADR. Now, here I would like to highlight one of the case that we had. This case involved one of the biggest giants around the globe and one of the biggest retail chain in India, where Amazon has invested around more than 1,400 crores in Future Group. Future Group is one of the biggest retail giants in India, where it was being taken over by Mukesh Dhirubhai Ambani, the Reliance Group, which is one of the prominent group in India. And there was a dispute where the Amazon started enforcing the arbitrators award, which was challenged in India under Arbitration Act. And at the end, Supreme Court said that since the award was enforceable, the judicial system admires the award and judicial system does not need to intervene in the same. So as I mentioned, that as in jurisdiction, we are focusing on the enforcement of awards when it comes to ADR. The key legislations that we have is Arbitration and Conciliation Act 1996, Pre-Litigation Mediation Rules 2020, Draft National Policy on Arbitration Mediation 2023. Various other initiatives that we have from the government is National Mission for Justice Delivery and Legal Reforms, the Arbitration and Conciliation Act, Mediation and Conciliation Project Committee, and others. And recently, even the government of India has proposed some amendments in the Arbitration Act as well, which is in draft and is submitted for the public comments. Now, what are the practical recommendations that we should follow in terms of India? So first is contractual considerations. We should be very specific when it comes to choice of law. Jurisdiction clauses is very much important. We should have an exclusive jurisdictions because the word exclusive is very much important when it comes to the jurisdiction. And of course, the arbitration clause. What are the rules for arbitration and which body should be governed when it comes to arbitration, which should be made very clear in contractual considerations. Parties should be very much clear as in what they want, whether they want arbitration as in first instance of dispute or something which they want to start with the litigation straight away, which is better and when they should choose the same. Uh, tips for just wait. Tips for foreign disputes in India. We have various international bodies coming up, which talks about various reforms, and the rules of specific centers are also carved in such a way that they have been in line with various international reforms. So in order to reduce the conflicts, I believe international foreign companies can enforce various international frameworks in Asia or in India specifically by choosing various arbitration centers in India, of course, by following, for example, ICC rules that may help them. The landscape in India is, of course, evolving, and we have been coping up with the ADR bill in India. Of course, we have been looking for various other jurisdictions who have been prominent. Say, for an example, Mr. Aziz, who is focusing on the Singapore. The Singapore has been one of the key prominent player. So India is evolving as in one of the ADR hub in Asia, and being one of the most populous country, it's very much important for us to figure it out how we can more efficiently use this ADR practice to help the litigants to solve their disputes in a timely manner. The challenges that we face is when it comes to arbitration. Of course, the awards of arbitrations are being challenged in the judiciary. And at the end of this thing, ultimately, the litigants suffer in terms of time and cost. The path to leadership, which I will say is to focus on the very specific provisions when it comes to the arbitration agreements or the arbitration clauses in the agreements. And ultimately, yes, the goal is to minimize the cost and the time for the litigants. Thank you. I thank you for giving me time and hearing me.
Thank you very much, Mr. Swar, for your insights on the dispute resolution in India. We now move on to our next speaker, Dr. Vanina. She's from Thailand.
Hi, good afternoon. And I know it's lunchtime for some of you, and I also see there's participants from Europe. So good morning, and thank you to With for having me. It is an honor to be here, and thank you to all the participants. I'm going to share my screen right now, and if there are any technical difficulties, please my apologies in advance because I'm not very tech savvy. And at the moment, I'm trying to find the share screen function. And okay, here. Now I'm able to find it. So we will be discussing Thailand. Hopefully, some of you have visited Thailand already, but I'll give you a little bit of an overview of Thailand as a country before we dive into the dispute resolution landscape. So these are the topics I will cover: overview and introduction of the Thai legal system, litigation in Thailand, as well as some of the challenges, which leads us to arbitration and the trends and development. And I'll touch a little bit on arbitration involving states. And finally, I'll give some final thoughts. In terms of overview of Thailand, it has 513,000 square kilometers, and the population has now grown to 71 million. It is the second largest economy in ASEAN with a GDP in 2022 of $495 billion and per capita of $7,000. And according to UNCTAD, the FDI reached 11.42 billion in 2021. Now, I don't have the statistics here, but the outflow of FDI within Asia coming from Thailand is also on the rise as well. One of the fun facts is that Thailand was one of the earliest signatory to the New York Convention, and it signed the New York Convention in December of 1958 and ratified it in December of 1954, more than 20 years before the United States. and 17 years before Singapore, and also before Hong Kong. So about the jurisdiction, Thailand is a civil law country. It is based on the European continental system. Those who are familiar with the French or German civil code will be easily familiarized with the Thai system. There is no concept of precedent as understood by common law lawyers or stare decisis, but Supreme Court decisions can be cited as persuasive. The major legislative codes that govern commercial relationships is the Civil and Commercial Code, and the Civil Procedure Code will govern court proceedings. There are, of course, other codes such as the Penal Code, the Criminal Procedure Code, the Land Code, and codes will then be supplemented by acts and other subordinate legislations such as ministerial regulations, royal decrees, etc. When it comes to the litigation framework, there are 3 levels of courts in Thailand: the Court of First Instance, the Court of Appeal, and the Supreme Court. There are also specialized courts for certain areas, such as the Labor Court, the Bankruptcy Court, the Intellectual Property and International Trade Court. This court will have jurisdiction over international arbitration awards that come and get enforced in Thailand, and also a separate system for government-related contracts, such as being the administrative court, which is similar to the French system. Now, when it comes to discovery, there's no general duty of discovery. Each party that is presenting its case will have to produce its own evidence that it is relying on. You can, of course, request a court to subpoena documents, but it would have to be a very specific document, such as a particular letter from such person on a certain date. Now, the length of trials can be quite lengthy, a year and a half, perhaps, for the Court of First Instance. And in the Court of Appeal, it can take a year and a half to 2 years, with a similar time period for the Supreme Court. And the appellate system is whether or not the is on an accepted basis, whether or not the Supreme Court will accept to hear the case. Thailand does not recognize foreign court judgments, so you would need to bring a new action. Now, the challenges with court litigation is that, of course, the length of the time, the lack of discovery, and the inability to recover legal cost. I'll show you the Judicial Independence Index that came from the World Economic Forum. Now, you can see different countries and where they rank. The highest ranking being 7, which is New Zealand. Thailand ranks a little bit about 4. The US is a little bit less than 5. And you see some of the other Asian countries. And this may be a factor of why you would want to choose arbitration over litigation. Now, when it comes to arbitration in Thailand, you need to know a little bit about the landscape. There's a Thai saying which is "Greng Jai Jai Yen Yen." Greng Jai means to be considerate. Jai Yen Yen is to basically have a cool heart. And this basically encapsulates the Thai culture. And in fact, the Thai approach to conflict resolution can be summarized as follows. According to Senior Judge Wichai, he stated that it is a non-aggressive, non-confrontational approach to dispute settlement, has been the teaching and practice of Eastern philosophers since time immemorial. Village elders, monks, and other leading local figures were and still are important catalysts in the judicial process. If a dispute arises, it is to these persons that the disputants turn rather than to the formal court system. This is particularly the case in rural setting. But one will notice at all levels of authority of justice, there is a mechanism for conciliation provided for from the head of village to a court, where the Civil Procedure Code alternatively empowers a judge to conciliate the dispute. I won't go into detail, but basically, both when it comes to arbitration and mediation, there is a process called in-court arbitration and in-court mediation, where the judge can where the parties can opt for arbitration that is governed by the Civil Procedure Code, and same with mediation, where the judge would often act as a mediator. So the concept of alternative dispute resolution in Thailand has been around since the beginning of the formal legal system, if not before. Now, the Thai Arbitration Act is based off the model law. So I won't go into details, but it has all of the common features that you will see in terms of the requirement for an arbitration agreement, separability, party autonomy, due process, competence. The difference would be interim measures, where arbitral tribunals are not empowered to grant interim measures, and the parties would have to resort to the competent court. And cost. Under the Thai Arbitration Act, the tribunal does not have the power to allocate cost. And by cost, I mean legal fees. The tribunal only has the power to allocate arbitration cost. And administrative contracts are arbitrable. And public policy can often be broadly interpreted when it comes to government-related contracts. There are two main arbitral institutions in Thailand: the Thai Arbitration Institute, which was founded in 1990, initially part of the Ministry of Justice, but now under the Office of the Judiciary. And now we have the Thailand Arbitration Center. And I believe some of you have attended the latest TAC ADR week, which started operating in about 2015, and the TAC rule largely models after the SIAC rule. There are, of course, more industry-specific arbitral institutions, such as the Office of the Insurance Commission. I won't go into the key features, safe to say that there are expedited procedures, small claim rules, and mediations when it comes to both institutions. Now, the key reform, first, I'd like to just mention the general attitude is that there is still a reluctance of parties to go to arbitration, and that is largely because the government has lost some major cases. But the landscape seems to be changing, and there is more of a movement to be pro-arbitration, especially now with Thailand trying to bid to host the advisory center for the Working Group 3 to advise emerging economies on ISDS. And when it comes to industry specific, the major industry that goes to arbitration in Thailand is construction. Now, the key amendment and the latest development is to allow foreign representatives and foreign arbitrators to sit in arbitrations in Thailand. And the amendment to the Arbitration Act provides for a mechanism to obtain a work permit through the arbitral institution. This was a huge problem in the past, and some may have heard the story of Neil Kaplan being arrested at the airport when he flew to the airport to sign an arbitration award and was hauled by immigration officers. And this was later on used as a tactic to raid arbitration hearings, to check for work permit. And this is one problem that now Thailand has tried to tackle with the amendment. And in addition to the amendment, there's also been provisions of smart visa to aid in arbitration proceedings. Now, I'll only say a couple of points about arbitration involving states. If any of you have been to Thailand and have flown to Don Mueang Airport, you may recall that there is a highway, a very long strip of highway called the Don Mueang Tollway. And this, the building of this tollway is what led to the first bilateral investment treaty case, which was the Walter Bao versus Thailand under the German-Thai BIT. Walter Bao effectively went bankrupt under the 30-year concession agreement because Thailand, it was alleged that Thailand granted another concession agreement to build a railway next to it, which will be the other project I'll mention, and also did not increase the toll cost and paved the road underneath in a way that nobody would take the toll. So the investor couldn't make money and basically went bankrupt from its investment. So Thailand lost the award, and as a result, and the award was 29 million euros. And as a result, Thailand has resisted enforcement in multiple jurisdictions in Switzerland, in Germany, in New York, and also in Thailand. And as a result of that, there's been a cabinet resolution to ban arbitration clauses in government contract. And because of this, there was a huge hostility toward arbitration. This has now changed, and the cabinet resolution has been lifted. And now cabinet approval is only required to be obtained in concession agreements, PPP contracts, and mega projects. And the hopewell is effectively similar to white industries. I won't go into detail since I'm running out of time. So I will just try to skip to the end. But safe to say that this case has taken on about 15 years already just to try to enforce the award. So the issue for consideration is that despite amendments to the Arbitration Act, obtaining work permits can still be a cumbersome process where foreign representatives and foreign arbitrators would have to come in with a non-immigrant visa and go to the hospitals to get health exams and go to the immigration office. The recent move of the Thailand Hearing Center to the government building and both the TAI are making it a little bit inconvenient. So the solution would be to have more centralized hearing centers. Another practical solution that we're hoping to see is specialized court that deal with only enforcement of arbitration hearing, so that of arbitration awards, so that the time can be shortened and that parties do not use this just to delay the process even further. Even though the courts have been pro enforcement, but the length of time that it takes has deterred parties from perhaps using Thailand as a seat. And as we would all like to promote arbitration in Asia, this would be one of the solutions. And that's it for my presentation. Specialized court, cooperation with the Ministry of Labor, some clarity on interim measures and allocation of costs, and more centralized hearing centers, and an increase in arbitrator pools. Thank you, and that is it.
Thank you very much for your insights into the rich tradition of Thai arbitration, Dr. Vanina, with its emphasis on conciliation and harmonious resolution, which are truly appreciated. Let's now hear from our next speaker, which is Mr. Aziz from Singapore.
Hi, sorry, good morning and good afternoon. I mean, to those who are attending here. Well, I think due to the fact that, first of all, I think, thank you, Saloni, for the introduction. There's just one mistake. I've not been in practice from 1967, rather 76. I think you got the figures sort of, juxtaposed in the wrong way. Anyway, I don't think you need to share my synopsis. I'll just go through this quickly. I come from a jurisdiction which is probably the most, in that sense, arbitration-friendly jurisdiction in the Asia-Pacific region. Now, what I've done here is just quickly that I'm not going to go through the court system because we are following the common law system where we have this, what is called the lower courts, which is divided into state courts and family justice courts and everything. And then they've got, of course, the High Court and the Court of Appeal. The Court of Appeal actually is known as also the Supreme Court kind of thing, but I'm not going to go into all the stuff. My emphasis here basically is more on the ADR scene in Singapore. Now, let me just jump in straight away into arbitration itself. See, in Singapore, what we have is an Arbitration Act, which I call as an AA. Now, this basically applies to domestic arbitrations, but at the same time, it also says that where this act itself applies and govern, those not governed by Part 2 of the International Arbitration Act. Now, I'm not going to go into the actual thing because that's something that you can, of course, do the needful as far as the search on the internet is concerned. But what is important to is to note the fact that by this International Arbitration Act that we have, what we are doing here is that we're actually accepting, or rather, the model law is incorporated into the law of arbitration as far as Singapore is concerned. Except, of course, for the part that says in relation to the enforcement of laws. Because since we're also a signatory of the New York Convention, we don't need want to have a situation where there could be a conflict in that respect. Now, what's interesting about this particular act is this, that the IA covers arbitrations where at least one of the parties to an arbitration agreement at the time that the arbitration agreement is concluded has its place of business in any state other than Singapore. Now, so what it would mean that in the situation where an arbitration agreement is signed, if of course both parties are Singapore parties, there's no question the A applies. But the IA only applies where one of the signatories of that agreement, not at the time of at the start of the arbitration, but rather the conclusion of the arbitration agreement itself. If that one party has got its place of business outside Singapore, then the IA comes into place. Now, as I mentioned earlier, this model law itself has been incorporated. Now, what is interesting, of course, is the fact that what has happened now is that we have accepted whatever has been sort of codified on 21st of June 1985. But the amendment itself, which has taken place recently, that itself has not been incorporated because we are still following the old model law in that sense of the word. Now, and the reason is because the certain provisions within the International Arbitration Act is, in that sense, has been updated over the years just to keep itself on par with what is the situation in a model, or rather in the international arbitration scene, so to speak. Now, we also have what is called an Arbitration International Investment Disputes Act. Now, this was, of course, signed, it came into force as early as in 1968. Now, this implements the Convention on Settlement of Investment Disputes. More so, why? Because we wanted to make sure that whatever awards that are made, in the event that an award is made, say, against a particular country which has its assets in Singapore, the courts will be more than willing to, in fact, enforce or rather allow the particular award to be enforced in Singapore itself. And it's not only as in that sense of the word, because we want to be friendly, right? So the idea is to show to the countries of the world that as far as they are concerned, if an award is made against a particular country which has its assets in Singapore, and if that particular judgment creditor sort of thing comes forward and wants to register the award in Singapore, that award itself will be registered for that purpose concerned. Now, what is interesting now is also now, what has happened now lately is that Singapore is in fact one of the centers, SIAC rather, where investment or rather exit arbitrations are also being administered by SIAC itself. So this is something that is, I think there's a step forward because it means that Singapore itself is being recognized as an international arbitration center. Now, what I've also included in my synopsis here is that as far as institutions, of course, I'm leaving aside ad hoc arbitrations, which are very few, because more often than not, what is happening is that if Singapore parties are not prepared to put in their SIC clause in the dispute resolution, or rather SICs and dispute resolution clause, they may of course bring in AIC or some other institutes. But the likelihood is that more often than not, most of the arbitrations that are conducted in Singapore are institution-based arbitrations. Now, I have, of course, in that sense, why I'm talking about ad hoc arbitrations, because there are situations where ad hoc arbitrations do take place. I've done a couple of that in Singapore myself. But the irony is this is only more for the smaller claims and between parties which are both in Singapore, not likely where foreign parties are involved. Okay, now coming back to the institution for arbitration, I'm just trying to move as fast as I can. You will see that we have what is called the Singapore International Arbitration Center, as well as the Singapore Institute of Arbitrators. Now, I forgot to mention this, But the Law Society itself, at a point of time when we had set, in fact, some years back, before even the mediation scheme itself was created by the Law Society of Singapore, we have in fact got a Law Society arbitration scheme. Now, this is more for lower claims, lower sum kind of claims, but at the same time, we're open to, of course, accepting claims which are of a very high sum. The problem is that so far, I think it is a question of recognition. The claims that have been coming forward to the arbitration center, which is administered by the Law Society of Singapore, is very few. And in fact, as far as the quantum is concerned, the amounts are not large. Now, the beauty of this particular scheme is that for a claim below 60,000, there is no fee payable to the arbitrator. And I was, in fact, have done one such matter several years back. And I'm glad that the parties concerned were so happy with the award, because they were saying that they thought an award of that nature would be something like just 2 or 3 paragraphs. No, I mean, the idea is this, that an award, no, regardless of the quantum that is being claimed by the claimant and of course disputed by the respondent, has to follow a certain format. And all these years, I think what I have done, at least as far as I'm concerned, and I think different people have different takes on this, but in my view, the ICC standard, which is applicable for how the award should be drafted, I think should be a situation, I mean, should be something that should be accepted by most arbitrators concerned. So that's something that I missed out earlier. Now, under mediation itself, we have what is called a Singapore Mediation Center, which was established way back in 1967. Now, those people are trained by this center are all considered as actually fellows, but none of us put the word fellow there in front of this. But we are all definitely known as accredited mediators. All right. Now, this particular body which was formed, initially, of course, it sort of took off only subsequently about a year or two later. Now, what has happened is, in that sense, the mediators concerned there, there's a panel called there's a, it's, you know, a panel of principal mediators, and then they have also what is called the, well, I can't remember the name now, but there's a lower sort of a stage of this, I mean, the mediation is concerned. Now, these people are appointed on the basis of quantum this thing that is that comes to the mediation center. And what is fantastic about this mediation center is that most of these mediations, as far as the mediation concerns, I mean, whatever matters are concerned, whether it's construction, uh, even say family matters, usual sort of commercial matters, which is sales of goods, uh, partnership disputes kind of thing. Most of these matters are usually either settled. If they're not settled, fine. But if they're settled, it is all done within a day. Now, Singapore Mediation Center has been very active in that sense. And I mean, I'm proud that I've been part of the center since 2002 January itself. Now, so basically what the center does is that this is like a one-stop center where they want to try to make sure that the parties be able to resolve the dispute before even it goes to court. And in fact, more often than not, when a matter is in fact started in the High Court, one of the first notices that comes to the litigants concerned is that please try mediation. So it becomes a situation where they're not forcing, but they're indirectly telling you that you better go and mediate first, in so many words. Because if they find out that mediation has not even taken place, it may have some kind of a bearing on the cost that you are seeking for, as far as the plaintiff is concerned. Now, we have various of course centers there. Now, we have also what is called the SIMI, that is the Singapore International Mediation. Sorry, it's the Singapore International Mediation Institute, it's SMI. There's a Singapore Construction Mediation Center, and there's of course the International Institute of Mediators. Now, the other one is that of course there's an international scheme. The international one takes care of this basis that whenever any arbitration from which is a foreign-based arbitration, or rather sort of parties come from foreign countries, one of the things that the arbitrator now can do, in fact, is to suggest to the parties, have they even considered mediation rather. So what may happen is that it in fact then ends up at this place called the Singapore International Mediation Center. All right. Now this is something that's very interesting. That's been set up just about several years back. So they, more often than not, in fact, they've been able to not only mediate, but successfully mediate certain claims to the tune of even up to $500 million. Now, this is on record. You can check that on the SIMC site. Now, the other thing the Law Society also has done is, like I said, if we have created a mediation scheme. Now, although this scheme has just started, let's say about 10 years back, but I'm in a sense proud to say that we have got a very good number of cases that have been coming, because the reason is being because of the fact that we've kept our costs low. So more often than not, the lawyers in Singapore are coming to the Law Society rather than going to the Singapore Mediation Center. Unless, of course, they feel that they just want a situation where, sometimes the parties themselves are willing to pay more, then it's different. Now, the last aspect that I want to emphasize on is this concept of neutral evaluation. As you can see, I've mentioned there is the company called FIDRAC. Now, FIDRAC is a Financial Industry Dispute Resolution Center. Basically, what it does is that this is a one-stop for institutions or clients of institutions, financial institutions, insurance companies, credit card companies. When they have a dispute among themselves, they can in fact apply to FIDRAC, and they don't have to pay a single cent, by the way. And a mediator is appointed. He's actually called a neutral evaluator. I'm one of them because I've done this over the years. What happens is that we are basically there after the papers are sent to us. We are just going there for an hour or two, listening to the parties and trying to see whether they can settle. If they cannot settle, what we have to do is, in fact, we are given a certain time of, say, about 3 days or 4 days to put in what is called a suggestion to the parties concerned. We call it an indication. It's all the standard forms which has been prepared by FIDRAC. We have to fill that up. We put that as an indication. Then it's for the parties to decide to accept or reject. It can be either for the financial institution or for the claimant, all right? Or we call them a complainant. But what is important is that in this scenario, it has been proven very good in a sense, because more often than not, the parties do accept the indication, which is then given by the neutral, who actually sits in then as a mediator, the role. But you see, in mediation, as we know, we are not there to try to impose our views on the parties. But because the way FIDRAC has been constituted, we are playing double role in a sense. We are a mediator, come a neutral evaluator. So in that sense, we are actually listening to the parties as a mediator, but when we are giving the indication, it is as a neutral. So that is how we covered ourselves. And so now, as you know, in Singapore itself, we have, of course, the Mediation Act, and that act is important because what it does is that it takes care of the fact that as far as mediators are concerned, when mediations are in fact conducted by the mediators concerned, we cannot be sued unless they can establish there's been fraud or there's some kind of foul play on our part. Now, other than that, I think I've got nothing further to add. And if there's any further questions that anyone here has in relation to the Singapore ADR scene, or for that matter, the litigation scene, I'll be more than prepared to answer. And of course, I would be prepared to answer questions because I'm trying to keep to the timeline. I hope that some people can raise the question in relation to the recent amendment that's taken place in relation to the rules of the Singapore International Arbitration Center, because this is going to be interesting, because that takes care of the situations, what the trend will be in Singapore. I don't have the time right now to speak on that. I am waiting for questions, and then I will be able to, of course, expand on that. Thank you very much.
Thank you for your insightful discussion on Singapore's robust framework for arbitration and mediation, Mr. Aziz. We'll now move forward with Mr. Izzat from Malaysia.
Thank you. Can you hear me?
All
right. Thank you. First of all, thank you very much to the organizer for having me. And I'm very honored to be part of this and to be presenting from the Malaysian perspective, along with very esteemed speakers that we have from around the world. All right, my name is Izzat Zamri. I'm being assisted by my assistant Sharifah Liana, who will be controlling the screen for the audience. All right. Now, this is the introduction. The Malaysian law system is a hybrid system that combines elements of common law system as well as Islamic law. And our supreme law is the federal constitution. That means there can be no no law or statutes that contravene the federal constitutions. And in respect of arbitration, we have two centers. As at 2023, we have all, apart from the Asian International Arbitration Center, AIAC, we also have the Borneo International Center for Arbitration and Mediation, that is in Borneo. So in Peninsular Malaysia, at the AIAC, and in Borneo, we have ICAM. In respect of litigation framework, this is how our court system is. Our highest court is called the Federal Court, and then below the Federal Court of Appeal, then we have the High Court, which is separated into two: High Court of Malaya, which covers all high courts in the Peninsula of Malaysia, and the High Court of Sabah and Sarawak, that is in Borneo. And then we also have the Sessions Court and the Magistrates Court. The difference between Magistrates Court, Sessions Court, and High Court is a matter of jurisdiction and the amount of dispute that is at stake. So, like for instance, any dispute, any civil disputes that involve amount below 100,000 ringgit Malaysia, that has to go to the Magistrates Court. If it's below, if it's above 100,000 ringgit Malaysia and below 1 million ringgit Malaysia, that has to go to the Sessions Court. And anything above 1 million ringgit Malaysia will have to go to the and the Court of Appeal and the Federal Court have the appellate jurisdictions. That means any decisions that was decided by the High Court can be appealed to the Court of Appeal and subsequently to the Federal Court. Of course, subject to certain conditions to be met, includes novelty of questions and constitutional issues. So resolving disputes would take up, 6 months, from 6 months to 2 years period in a specific court. So like for instance, if a dispute is brought in the High Court, usually the court will try to dispose the matter within 9 months time, so 6 to 9 months time. But however, of course, if there are many interlocutory applications or other matters that you consider prior to the trial of the action, then the time limit from 6 to 9 months may be extended. So the challenges that there can be backlog of cases, delays, and it will also occur issues of enforceability because we do not have too many judges to hear cases. Of course, judges will also hear a lot of cases, and now we also have the specialized courts that will hear specific courts that I will share with you in a bit. All right, now we go into the ADR. Of course, the ADR options available similar to what have been presented by the earlier presenters, so arbitration, mediation, as well as negotiation. And the strengths of ADR, as a lot of people believe it is that it is faster, speed, maintains confidentiality, and flexible. So flexibility is better in ADR as compared to litigation. And the recent trends in ADR adoption includes online dispute resolution to resolve minor disputes among SME and private sectors, as well as the enforcement of Construction Industry Payment Notification Act 2012. So this act, the 2012 Act, is a very interesting act that was created for the purpose of resolving disputes in construction industries. That means any disputes can be brought through this process, and it will be resolved or decided by the adjudicator within 45 days after all papers are in order. So that means the adjudicator will have 45 days to deliver decisions. So that is obviously a lot faster than even court application. And the purpose of having this act is because of the rising numbers of the construction disputes in Malaysia. And we want to make sure that those disputes do not hinder the construction progress. All right. For cross-border considerations, similar to what has been presented by my other presenters earlier, Malaysia also acceded to the New York Convention. Malaysia is also a party to the ASEAN Comprehensive Investment Agreement. And also, as mentioned by Mr. Aziz earlier, similar to Singapore, Malaysia is also a party to the Convention on Settlement Investment Dispute States and Nationals, other states. Say fine. In Malaysia, what is different is that we have this act called REJA, a short form to Reciprocal Enforcement of Judgment Act, an act that is created to allow parties to register judgments that have been entered or obtained in the UK, Hong Kong, Singapore, New Zealand, Sri Lanka, India. So any judgments that have been registered in any of these countries can be registered in the High Court of Malaysia, so that the dispute do not have to be re-litigated if it is to be enforced in Malaysian jurisdiction. So the industry-specific insights, of course, as I mentioned earlier, we have this construction SIPA Act, and construction disputes are largely resolved by arbitration, court litigation, mediation, and statutory adjudications. So nowadays, in Malaysia, almost all construction disputes will try to be resolved through the statutory adjudications. Of course, the decision of the adjudicator through the statutory adjudication may be challenged to the High Court. ADR also facilitates construction dispute resolutions with support of international arbitration, and it offers remedies for construction payment disputes, including cross-border projects. Now, in respect of recent legislative and policy developments, there are reforms and updated regulations as well as government initiatives that we wish to highlight today. The reform is the Arbitration Amendment Bill 2024, which will provide more efficiency and effectiveness in the arbitration process. But at the end of my presentation, we'll try to leave the audience with a question that I would like to discuss, maybe at the questions and answer session later. The updated regulations include the third-party funding provides financial supports for legal proceedings in exchange for share of winnings. And in respect of government initiatives, there are also pro bono mediation services and online dispute resolutions. So there are a lot of initiatives in Malaysia and options for parties to consider to bring disputes to. So it's not just litigation and arbitration, there are also negotiation, so mediation, similar to what we said presented in Singapore. In Malaysia, we also have Malaysia International Mediation Center, which a lot of people nowadays more willing to bring their matters to the mediation centers because of confidentiality, and perhaps they can try to resolve their matter faster instead of bringing them to court for arbitration. All right, so this is the conclusion of my presentation today. In my opinion, Malaysia dispute resolution framework is robust, with accessible courts and possible international judgments and diverse methods of arbitration and mediation. Advancement in online dispute resolution enhanced efficiency, making Malaysia a preferred choice for resolving disputes. One issue for consideration that I maybe can discuss is from the Malaysian perspective, I think I would like to raise the question whether or not alternative dispute resolution such as arbitration and mediations is really the most is really the best method for dispute resolution as compared to court litigation. When we take into consideration in Malaysia, the practice is for court litigation to be determined or to be decided within a short period, that is within 6 to 9 months. That is the KPI for the courts to meet, right? Of course, there are some cases which will be dragged longer, but 6 to 9 months is generally the time limit where the courts like to dispose their cases. So in that respect, in terms of speedy conclusion, the courts is probably better than arbitration. Apart from that, the Malaysian courts also has a center that's called court mediation center. That means any matters that is brought to court can also be mediated through the mediation center in the court. And the mediator in this court mediation center are trained mediators that are appointed by court. Everything that, of course, being brought is court mediation center are also privileged, and it basically confidentiality is ensured. And then the third is that in Malaysian high courts, right now we have at least more than 5 specialized courts. So we have the construction courts, we have family court, we have banking and muamalat courts, we have admiralty court, we also have the intellectual property court. So there are already a number of specialized courts that will hear specific type of disputes in order to ensure that disputes that are being brought to court are not are basically disposed as soon as possible. So of course, in the past, people always think of arbitration and thought that arbitration is probably the best way to go, as it can ensure a speedy disposal of the dispute. But nowadays, Malaysian courts can already ensure it. So that's why I raised the question that I mentioned earlier. I think that is all I have to share. Maybe further discussions can be done subsequently.
Thank you, Mr. Izzat, for sharing your insights on Malaysia's practice and the evolving dispute resolution landscape. Next, we'll be hearing from Mr. Djamel from Cambodia.
Okay, so greetings to everyone. My name is Djamel Akra. Yes, I am French, but I am located in Cambodia since 12 years already. But for a few days, actually, I am in Malaysia. So greeting also to my Malaysian panelist friend here. I'm sitting in the majestic hotel just in front of AIEC. In the introduction, you mentioned 2 important words, ESG and Malaysia. 2 days ago, actually, we just launched the ESG ADR forum at AIEC. So that's also a kind of symbolic event. So moving forward, today I will take will have my hat of registered arbitrator in Cambodia in the National Commercial Arbitration Center to talk about dispute resolution in Cambodia. I'll try to stick to the 10 minutes as I've been told that this is a 10-minute talk. Well, the hybrid nature of the Cambodian legal system may be a debate because of course, this is a civil law system, really similar to the French legal system. But there are also other legal traditions that come into play, such as customary and also religious principles, especially based on Buddhism. And recently, there are also influences from common law countries, especially in the commercial legislation. But predominantly, Cambodian legal system is based on the civil legal tradition. So we can say that this is a civil law legal system. About the key institutions involved in dispute resolution, the courts, the local authorities are, of course, involved in that. As per the courts, well, you have really similar to the French legal system, the first instant courts, the appeal courts, and then the Supreme Courts, which has competence only to decide on legal principles. About the national government institution, they may be also involved in dispute resolution, either as a conciliator or mediator. We may talk more about conciliation here in this specific topic, but only in specific sectors under specific laws. For example, the Ministry of Labor will have competence to hear for dispute related to labor dispute related to labor between employee and employers, but only as a conciliator. Another example is the Ministry of Economy and Finance that may also act as a conciliator in public-private partnerships related disputes between the implementing agency and the private partner. And other ministries, such as also the Ministry of Commerce for trademarks related disputes, also acting as a conciliator. National authority as well. Recently, there were a national authority for alternative dispute resolution established in Cambodia for the past 2 years. Yes, so this NAADR is also competent. So it's under the Ministry of Justice and is competent to hear or to try to mediate dispute related to everything except for criminal cases. So it could be land dispute, family dispute, really a broad range of dispute that they may help to mediate. But the mediator are not employee of the ministry, but they are required to pass an exam and also take an oath. As per to the arbitration centers, there are 2 arbitration centers with different jurisdiction. The Labor Arbitration Council is competent to hear labor disputes, employment disputes between employees and employers. But for now, it is just competent to hear disputes related to collective labor disputes. So mostly related to collective bargaining agreements or disputes raised on behalf of employees by the unions. But in the future, there are also potential update, and the labor law, I will discuss about that, but the labor law has been amended also to open it to individual disputes. As per the arbitration center in the commercial field, the National Commercial Arbitration Center, which I am registered as arbitrator, is the only arbitration center in Cambodia. So I will go maybe more in detail about the NCAC. But for now, just the litigation framework. I already explained about the legal, the jurisdictional system. But the law and the organization of the courts actually divides the jurisdiction into specialized courts. But actually, those specialized courts, the labor courts and the commercial courts, have not yet been established. So this is a project for the future as well. As part of the ADR legal framework, Cambodia is a party to the Washington Convention, the Convention on the Settlement of Investment Disputes between state and national of other states, and the New York Convention as well. And Cambodia is actually a dualist country, so there is a law to implement the New York Convention into the national system. But the main legal framework for commercial arbitration is based on the law on commercial arbitration, the 2006 LCA, and other regulation implementing the LCA. So the LCA is a model after the ancestral model law on international commercial arbitration, but in its 1985 version. So the law on commercial arbitration covers all aspects of an arbitral proceedings, arbitration agreements, court support, tribunal composition and jurisdiction, arbitral proceedings, the matters, award making and termination of proceeding, as well as enforcement. So some aspect of the National Commercial Arbitration Center arbitration rules. So just to give some backgrounds here, the NCAC has been established in 2013. So the LCA is 2006. So formally, the NCAC has been established in 2006, but actually it has been only operational in 2013. So we have celebrated the 10 years of the NCAC this year, at the end of the last year. So some aspects of the arbitration rules that are actually reflecting also what we can find in the law on commercial arbitration. First, about the scope. It applies to commercial arbitration within Cambodia. And there are no distinctions between international or domestic arbitration. The arbitral institutions, the LCA actually has a significant feature because it creates the National Commercial Arbitration Center. So the National Commercial Arbitration Center is not privately held like some other centers in the region, but it is created by law. Actually, this is the NCAC is a membership-based organization. So the members, for example, I am one of its member, and we elect the board of directors also. So this is an institution which is controlled by its own members for the benefit of its user. So just some features of the arbitration rules, just related to the language of arbitration. So the parties can agree on the language. So it could be whatever language in principle. But when it comes to the language of proceedings, the party are free to choose it, of course. But for the language of the award, it will be either in Cambodian language or English, mostly because the scrutiny process require the secretariat to conduct it, and the award will be therefore in English or in Khmer. Otherwise, yeah, for the proceedings, the language of the proceeding, the tribunal can decide based on what we already know, based on the circumstances of the case, of the language of the contract, etc. For the place of arbitration, the default seat will be in Phnom Penh, Cambodia, but the parties are free to choose also the seat, even though they are using the NCAC arbitration rules. And NCAC can also administer cases under other arbitration rules as well, according to its rules. But interim measure, the tribunal can take interim measure, but as it comes to enforcement, the law does not really specify it, but in practice, it will be for the court to enforce it. Also, the new arbitration rules, the 2021 arbitration rules of NCAC has introduced the emergency arbitrator proceeding, which can allow the party to settle their dispute within less than 6 months. But the expedited procedure, which is also available under the NCAC arbitration rules, it is available for dispute not exceeding 3 million USD, or in case of exceptional urgency, or when the parties agree to use this expedited procedure. Yeah, for the emergency arbitrator, it will depend, but for the expedited procedure, it will be that the proceeding will be conducted within 6 months. Sorry for the confusion. The multiple parties and consolidation, the rules also allow for third-party joinder or for consolidation of arbitration. The joinder can be decided by the tribunal or the institution, but when the tribunal is constituted, the tribunal will have power to also allow such a joinder. But as for the consolidation, it will be for the institution to decide on it. So for some challenge and opportunities in cross-border disputes, actually, and also about recognition and enforcement of foreign judgments, I will discuss about those both matter. Cambodia, actually, foreign judgment cannot be enforced in Cambodia unless there are reciprocity or bilateral agreements, which is the case with Vietnam only. So arbitration can be a solution to that. About other perspective, Cambodia is not a signatory of the Singapore Convention on Mediation. So it will be interesting to see, as the NCAC has also launched its mediation rules this year, how Cambodia will also enable the parties to have a more developed framework for international mediation, because there is no legal framework on outside court mediation. Maybe the Singapore Convention may help to develop such legal framework, even though the Ministry of Justice is working on it since the launch of the National Authority for ADR. So we are in a kind of a period of testing how mediation can be conducted without considering any legal framework. For regional collaboration influencing dispute resolution, 3 months ago, I participated to an event related to cross-institutional rules. So how can such collaboration may be beneficial for centers in the region? That also could be a matter to consider. Just as a conclusion, some key legislative and reforms impacting dispute resolution in Cambodia. So as I mentioned, we are looking forward how specialized courts and especially commercial courts will be helpful to support commercial arbitration in Cambodia. Also, how the image of mediation will be diffused, especially since the establishment of the National Authority for ADR, and how can a center like NCAC will be able to handle mediation more effectively. And I think the lack of legal framework for mediation of commercial dispute, I have already mentioned that. So I think this is, for me, about the resource or contact for further assistance. I will be open to answer any question the audience may have within this webinar or even after. But the key resource will be to contact, of course, the NCAC Secretariat to have more information. Just to conclude on that, some statistics, the NCAC have received 47 cases for the past 10 years, and with a total of 160 million USD for the amount implied in the cases. So I think it's, yeah. So thank you for your invitation to this webinar, and I will be available to answer any question as I see that my time is up. I'll stick to the 10 minutes. Thank you very much.
Thank you very much, Mr. Djamel. Your perspective on Cambodia's dispute resolution was very insightful. Now let's move to our last speaker, who is Mr. Lavesh from Hong Kong. Over to you, Mr. Lavesh.
Hi, yes, I'm just pulling up my PowerPoint now. I also want to thank With Law for the invite today, and it's been great listening to all of my esteemed co-panelists speak on their different jurisdictions, and it's been very enlightening. So obviously I'm from Hong Kong. I'm a barrister. In Hong Kong, we still have the split profession between barrister and solicitor. So we don't have a fused profession like in many other jurisdictions, like Singapore, for example. So we still have people who specialize in advocacy and those who do general litigation work as well on the side. So Hong Kong is a common law jurisdiction. It remains a common law jurisdiction even after the handover from the British back to the mainland China in 1997. The constitutional framework in Hong Kong is based on the Basic Law. And the Basic Law essentially sets out all the different entities and bodies in Hong Kong and what powers and jurisdictions they have. So essentially the legislature and the judiciary and the executive body and how they balance each other in essentially in the separation of powers. So obviously, because common law is still binding in Hong Kong, we still use the principle of stare decisis, and it's still applicable all throughout. Separate from that, I mean, because Hong Kong is still a common law jurisdiction, it's actually very common for us within the jurisdiction, as in other common law jurisdictions, to borrow and share from each other. So actually, even recently, I've been citing Singaporean judgments, Malaysian judgments, UK judgments, Canadian judgments, basically judgments all throughout the common law. And obviously, we can take some parallels and some ideas and see how they develop. And you'll see that's also reflected in how the Hong Kong court system works as well. So before we get to the court system, just some basic facts about Hong Kong. Hong Kong is the world's third largest global financial center, behind New York City and London, according to the GFCI in 2024. And according to the WTO, Hong Kong is the 10th largest trading entity in merchandise trade and the 21st largest in commercial services. And obviously, a large part of that success has to do with the rule of law and the independence of the judiciary in Hong Kong. It also helps that Hong Kong is closely tied to the mainland China, and there's a lot of business that flows between the two jurisdictions. Separately, Hong Kong is also a leading commercial center for dispute resolution. So where do you find laws here in Hong Kong? They're essentially come from two main sources. So they come from statutes, which are enacted by the legislature, and case law, which is developed through the courts. In terms of some of the key statutes in Hong Kong, we obviously have the Arbitration Ordinance, which is used in terms of arbitration procedure and how awards are enforced and whether they can be refused or not recognized. And we also have a mediation ordinance, which is also helpful in terms of helping make sure that mediation agreements and settlement agreements entered between parties will be binding and enforceable. Separate from that, Hong Kong recently enacted the CISG, so the Convention for the International Sale of Goods, back on 1st of December 2022, and it now applies in Hong Kong throughout. It obviously applied in China before that, but is now binding in Hong Kong. In terms of how Hong Kong has an interplay between itself and other jurisdictions and recognizing and enforcing judgments, we have the recognition, reciprocal enforcement of judgments, of foreign judgments. So in Hong Kong, we have it through the statutory regime, which exists, and separate from that, in parallel, there still remains a common law regime where both are enforceable. So the hierarchy of the Hong Kong court system is very similar to what was discussed by Vanina in Thailand and Izzat in Malaysia, as well as in Singapore. So there's obviously a first instance court, a court of appeal, and then a Supreme Court, the apex court, which in Hong Kong is called the Court of Final Appeal. What's interesting about Hong Kong's Court of Final Appeal is that not only do we have judges from Hong Kong who sit, so we have the Chief Justice, some permanent judges from the Court of Final Appeal, but we also have non-permanent judges, which can either be from Hong Kong or from foreign jurisdictions. So, for example, we have Lord Hoffman, who comes and sits in Hong Kong at the Court of Final Appeal, as well as Lord Newburger, the former president of the Supreme Court in England. And we also have judges from Australia currently right now as well, Mr. Justice Robert French, who was the former Chief Justice of Australia. Now, you'll see on my slides right there, there's essentially the High Court, which is the Court of First Instance and everything above it, so the Court of Appeal and Court of Final Appeal. But we also have a series of inferior courts and tribunals. So we have the Labor Tribunal, the Family Court, the District Court, where disputes are up to $3 million, and small claim tribunals, amongst other things. So obviously, it's just a matter of finding what is the correct court in order to file a claim and then proceed from there. Now, in terms of how the litigation framework in Hong Kong works, it's changed quite a bit with the enactment of the civil justice reform back in 2009. So the civil justice reform has helped in order to increase the cost effectiveness of the court proceedings and to ensure that the courts have greater and wider use of case management powers so that they can ensure that everything proceeds as quickly and as smoothly as possible. It's also there to help ensure that costs are minimized and so that parties are not put to great expense and they can get a judgment as quickly as possible. So this is in line with what some of my fellow speakers had said. In terms of the courts nowadays are trying to make sure that they can get judgment as quickly as possible. So in Hong Kong, you can potentially have a case, get judgment for a court of first instance case between 12 to 18 months on average, I would say. But if you manage to get an expedited hearing, or if there's a greatly urgent hearing, you can have one even quicker. A few years ago, I had a potentially expedited hearing, and I had a hearing date within 4 months from when the action had started. Obviously, that's a rarity. It's not something that happens very often, but it does show how quickly the courts can act when there is a need to ensure that speedy justice is resolved. Now, obviously, all my co-panelists have talked about this. There's essentially two main forms of ADR dispute resolution that everybody considers and talks about. Obviously, arbitration is at the forefront of what most of us legal practitioners look at. There's also mediation, which is the third-party settlement of disputes between parties using a third party to help resolve that. Now, I can say that in Hong Kong, there's been a pilot scheme that was enacted in the district court whereby there has been a huge promotion of mediation and, in fact, court imposed mediation, where parties are then forced to go to mediation with a judge sitting as a mediator, helping to try and resolve the disputes. Now, some of the factors in doing that is to make sure all the parties must be in the room and show up, and it kind of puts pressure on them to try and start to resolve disputes. And I think there has been some positive outcomes that have resulted from that. And I think mediation does help, at least if not settle a dispute, narrow some of the disputes between the parties. Yeah. Obviously, one of the leading arbitration centers in Hong Kong is the HKIAC. It was founded in 1985. It is now the third most preferred seat for arbitration in the world, according to Wedding Case in 2021. They specialize not just in arbitration and mediation, but also adjudication and domain name dispute resolution. In 2024, the rules were amended to enhance efficiency, environmental sustainability, and information security in arbitration proceedings. So in particular, there was a few key updates in the most recent set of rules. So there was a mandate encouraging parties, co-arbitrators, and the HKIAC to account for diversity when determining the number of determining and confirming arbitrators. There were new powers allowing the arbitral tribunal to give directions to parties to protect the security of information involved in the arbitration proceedings. There was a new list of factors for arbitrators to consider when making cost determinations, including taking into account the environmental impacts of the party's conduct in an arbitration, essentially to try and minimize the amount of paper that is being used in arbitration proceedings. There was also an introduction of a hard stop time limit for the close of proceedings. So it's 45 days from the last oral or written submissions, and from the issuance of an award, 3 months from the close of proceedings. So there's also just been more express case management powers for the arbitral tribunal to assist in efficient conduct of the arbitration proceedings, including quickly determining preliminary issues as well as bifurcating the proceedings, so splitting the proceedings up. Now, in addition to the HKIC, there's obviously a few other arbitral institutions that exist in Hong Kong, CTAC, China Maritime Arbitration Commission, and the ICC, just to name a few. Now, obviously, one of the biggest benefits of arbitration is confidentiality. It allows parties to ensure that they have confidentially resolved their disputes, and so that they can then try to do it as quickly as possible without the fear of any negative publicity. And also, the biggest factor in support of arbitration is obviously the New York Convention and its expansive ability to be enforced throughout the world. It used to be the case that arbitration was also very cost effective, but I would say nowadays, in my personal experience, that the costs of arbitration are definitely on par with litigation, if not more at times. And with respect to mediation, it's clearly cost effective because it helps you resolve the dispute at the quickest and earliest opportunity possible. It is confidential as well, and it gives way to party autonomy. So a unique advantage in Hong Kong with respect to ADR is the arrangement between Hong Kong and the mainland China, where we have a special arrangement for interim measures, which allows Hong Kong, specifically only Hong Kong, to be able to seek preservation orders within the PRC. And this has resulted in 26 applications to preserve about $7.6 billion, and with there having been orders and applications approved in the sum of 1.26 billion in the mainland China. So in terms of cross-border considerations, Hong Kong is hugely pro-arbitration jurisdiction. You'll see that reflected in almost all of the arbitration judgments for enforcement, as well as where there's been any issues of considerations of whether to refuse enforcement or to set aside an arbitral award. And in fact, the courts have recently made decisions saying that if parties are abusing the system, that there may potentially be orders on a wasted cost order basis. So there's obviously regional, there's a bunch of conventions that are binding between Hong Kong and the world, particularly the New York Convention I mentioned earlier, as well as a specific arrangement between Hong Kong and Macau and Hong Kong and China. I think one of the most interesting areas of development in Hong Kong has been the interplay between winding up and arbitration proceedings. I've actually argued both sides of this specific issue. whether one should actually favor winding up or arbitration. And obviously, Gai Kwok Lam was the most recent judgment in Hong Kong, but given the Privy Council decision in CN participation, which just came out earlier this year, it'll be interesting to see how some of these cases are now going back up in the context of arbitration in the Court of Final Appeal and seeing what the court will decide over there. So in terms of practical recommendations, I think it follows along the same lines of what a lot of my fellow co-panelists have been saying in terms of ensuring that you properly draft a arbitration clause, ensuring that you've actually complied with the terms that are required in there. For instance, if there's a notice provision, making sure you comply with it. And obviously, I think both ADR and litigation have their merits in terms of which is to be preferred or not preferred. I think that's just a matter of what are the outcomes or what are parties looking for to resolve that dispute, whether confidentiality is a priority, speed, cost. So these are all multiple factors to take into account. Obviously, if you want a right to appeal as well, you would prefer to have litigation versus arbitration where there's no real mechanism of appeal at all. So in conclusion, the most common forms of dispute resolution in Hong Kong are litigation, arbitration, and mediation. There have been many initiatives in Hong Kong to promote court efficiency, including the civil justice reform, the integrated CMS provision, which is now starting to try and create the use of e-filing in Hong Kong. And obviously, Hong Kong is very much a pro-ADR jurisdiction in terms of how it resolves disputes and how it tries to promote it as well. Thank you all very much, and I look forward to having any questions.
Thank you, Mr. Lavesh, for your expert insights on dispute resolution in Hong Kong. The efficient dispute resolution system adds a significant value to today's discussion. Now let's move on to the Q&A session. Okay, we first question for Mr. Djamel. The question, including updates to arbitration provision and institutional rules around the world and Asia, shaping a sustainable regionally.
Can you repeat the question?
Yes, I will. The question is, how are recent legal reforms, including updates to arbitrational provisions and institutional rules around the world and Asia, shaping a sustainability regionally?
As for Cambodia, there were not any amendment to the law on commercial arbitration since 2006, but the Ministry of Justice and Commerce may be working on revising the law, but this is not really a big matter for now. For example, the aspect of confidentiality, actually it's not included into the law on commercial arbitration, but it's only integrated into the NCAC arbitration rules. So that could be a matter of importance to consider for further reform. As for the NCAC arbitration rules, the last version was 2014, and the new version is 2021. As I've mentioned, the emergency arbitrator expedited procedure has been included in line with some other institutions. Also, new rules on mediation has been adopted, opening the door for an administer med-arb or arm-med-arb process. But the problem will be to consider, or the issue to consider would be the enforcement at the domestic level of settlement agreement. For settlement agreement actually made by the NAADR, there is a kind of authentication that will allow for enforcement and recognition. But for a private settlement under NCC, for example, or the ad hoc mediation, usually what can be done is notarized authentication, for example. So as for international amendment, I see that Mr. Aziz maybe also have some updates maybe about the Singapore, the SIAC new rules adopted in 2025. So maybe it may complete also the question.
Yeah, thank you very much, Mr. Djamel. Our second question is for Dr. Vanina. The question is, what new technologies and methods could be adopted for dispute resolution in Asia in the future?
Hi, thank you for the question. What is at least is already being adopted in the with the Thai Arbitration Institute is electronic filing. And I know that the THAC is currently exploring various companies that provide AI for case management. And I think that goes to the sustainability matter and how arbitration is advancing sustainability by using less paperwork and spending more on electronic filings, as well as the more prevalent use of virtual hearings.
I agree with that, Dr. Vanina. Okay, we have our next question for Mr. Swar. The question is, what are the potential areas for ADR in India? Indian government, as the government is the biggest litigant in any courts, how to implement ADR in such cases?
Okay, it's pretty competitive question. I mean, so would like to discuss with my panel of experts as well. But when it comes to India, of course, the government of India is focusing on various bodies to decrease the time of disputes. So as a result, what is happening now is government is coming up with and more reforms when it comes to the appellate authorities. So the government is trying to reduce the times for the disputes and appellate authorities. And by doing this, what government is doing is that to reduce overall the dispute cost and the time which the litigant has to face. The second thing, the now centers like Mumbai Center, International Arbitration Centers, some other arbitration centers in IFACA and others in Delhi and Mumbai are also focusing on adopting various frameworks apart from their own framework. So what I believe is now the ADR landscape is India is evolving. Of course, most of the dominant part in ADR in India is being guided by the retired judges. But of course, with the exception of international frameworks like ICC and of course ACIAC, now various companies in Asia are also focusing on opening this ADR concept by adopting various international frameworks. That's what I believe. Thank you.
Okay, we have another question for you, Mr. Swar. The question
Okay.
is, can blockchain-based smart contracts truly eliminate the need for arbitration in specific disputes, or will they create new challenges?
Very interesting question. So, you will be amazed to know that in way back in around 2018 or 19, Chinese judiciary had accepted evidence which were backed by blockchain technology. So, blockchain nowadays is something which we feel is an emerging technologies. But when it comes to judicial proceedings, it's amazing to know that the Chinese government and the judicial system have been adopting and have the first case involved of blockchain evidence way back in I think 2018 and 19. So when it comes to a contract based on blockchains, I believe the disputes in terms of the understanding and the interpretation of the contract will of course reduce. But given the circumstances of technology, it's very interesting to see how things go when it comes to the understanding of the parties using blockchain for signing the contracts.
The attendee must have got a good, perfect answer. Okay, we move on to the next question. Is for Mr. Lavesh, which is which are the different ways to expedite the process of dispute resolution in commercial dispute?
Well, I mean, obviously, the quickest way to try and resolve any dispute is to try and negotiate directly with the opposing party. The quicker you can bring them to the table and you can see where you both stand and try and minimize the areas of dispute, that's obviously going to be the quickest way. In terms of speeding up in court proceedings or anything else, I mean, depending on the nature of your case, you could either adopt expedited proceedings or you could see if you have a summary judgment application that's open to you. But otherwise, if you're going through either arbitration or litigation, it's going to take as long as it takes depending on the nature of the dispute. The best way to speed it up is probably through mediation and negotiation.
Thank you very much, Mr. Lavesh. The next question is for Mr. Izzat. It is with the Proliferation of virtual hearings. How should dispute resolution institution address digital divides in rural or less developed parts of Asia?
Hi, thank you for the questions. For your information, in Malaysia, actually, even before COVID, we already have a system called the case management system through e-review that is done online, where all case managements are no longer done uh, in open court. That means lawyers do not have to go to court anymore to case manage their cases. And most of the cases that are to be heard for interlocutory applications hearings are all done online. Even court trial that involve examination of witnesses too are still being done online right now. So that is insofar as Malaysian effort in terms of ESG support.
Thank you very much, Mr. Izzat. We'll move ahead with our next question for Mr. Djamel. It is how we can litigate overseas. What is the qualification and is there any exam or license to be availed for participating internationally?
Well, I think the scope of the question is a little bit broad, but from what I understand, litigate, you mean litigate overseas or in different jurisdiction where you are qualified, or you mean bringing a case to an international jurisdiction? Is there any specific orientation to this question? Otherwise, no, there is no specific qualification unless the qualification provided by each domestic jurisdiction.
Thank you so much, Mr. Jamil. Okay, we move on to our next question. We have two questions for Mr. Aziz. The first question is, how can we change our education system? And if we, then what other changes we will be regarding to our nation?
Well, I didn't expect such a question. You're talking about education system where? In India?
Or in your jurisdiction, sir, the Singapore.
Well, I mean, I think okay, if you want to be asking me from my perspective, I think our education system is pretty well run in a sense. So I don't think there need to be any changes. Only things, of course, I mean, from the parents' point of view, it's always a question of, whether there's too much for the children to do, even at what is called we call it primary 6. That means, they call it entrance exam before the student moves on to the next level, which is secondary education. Because, and then there's a certain amount of grading there. I mean, kind of points you get. So, but I mean, sorry, but I don't think I can give you a satisfactory answer. And what's the second aspect of the question?
The second aspect was if how can we change the education system, and if we, then what other changes it will be regarding what changes can be equipped for
No,
the.
no. Well, I'm sorry, I really can't answer that because I mean, first of all, I'm not within the Ministry of Education. I mean, unless it's related to arbitration, then because you see, as far as arbitration is concerned, I mean, we all know there are various ways to join various kind of courses, kind of thing, right? I mean, I'm okay. Okay, if I can be just speak about arbitration concern in education. In Singapore, we have to go through, if you want to be an arbitrator, there is called a basic course and then the award writing course itself, which is conducted by the Singapore Institute of Arbitrators in conjunction with the Chartered Institute of Arbitrators. Okay. But there's some people, in fact, what they do, beyond that, of course, you can get a diploma in international arbitration, which is a course being offered by the University of Singapore, or now it's called National University of Singapore. So, I mean, if it's related to that, fine. As far as mediation is concerned, again, the training has to be gone. One has to go through the Singapore Mediation Center to be accredited or otherwise. I mean, if you're asking me about that, that's fine. But if you're asking me about education system in general, I'm not in a position to help.
Okay, thank you so much, Mr. Aziz, and I hope the question has been answered. Miss Dr. Vanina has raised her hand. Okay, sorry. So the next.
Hi. I was actually going to help answer the previous question about practicing in other jurisdictions, but perhaps you could bring up
we
the
can
question
continue.
again.
We can continue. We can also hear your opinion for the same.
Oh, if you could repeat the question
I,
again.
I will repeat the question. The question was, how can we litigate overseas, and what is the qualification, and is there any exam or license to be availed for participating internationally?
Okay, I can give the answer for certain jurisdictions just from my experience. Well, to litigate in court, of course, you have to be a licensed attorney in that jurisdiction. It, so if you want to go to court in California, which is where I'm licensed, then you have to have passed the California bar and be sworn and pass the bar, and also go through the moral character exam, and then take the oath. And then once you're registered with the bar, then you can appear and litigate in court. There's no distinction between solicitor and barristers, which is a distinction in the UK. Now, but here we're talking about dispute resolution, and many of us are interested in arbitration and international arbitration, and perhaps working in other jurisdictions. From my experience, some countries will have a foreign lawyer scheme where you can be registered as a foreign lawyer, but of course you're then prohibited from litigating in court of that jurisdiction. So for example, when I spent a few years working in a law firm in Paris, I was registered as a foreign lawyer, or called an avocat étranger. But that status is only available for 3 years. And if I want to stay beyond that, I would have to take the Paris bar. Similar to Hong Kong, I was registered as a foreign lawyer when I was practicing there. And now in Singapore, where I'm currently working, I am registered as a foreign lawyer, but I cannot practice Singapore law. But what I do is international arbitration under other law, or would work with Singapore Council. There are ways to get second qualifications, of course. For example, with the UK, if you have certain years of experience in your jurisdiction, you can get waiver to a certain of the first part of the exam, and then take the other part. Or if you want to get qualified in the US, then depending on the state, you may need to take the LLM before and then sit for the bar in New York or California, depending, but it's jurisdiction specific. In Thailand, it's only reserved to Thai nationals, so foreigners cannot be qualified to practice Thai law.
Thank you so
Yeah.
much, Doctor.
Sorry, if I may just be able to add up to that. Vanina is correct. I mean, because you see, every jurisdiction protects its own sort of, people who must be qualified to be able to appear in its own courts, right? But there's a distinction as far as arbitration is concerned. And that's a beautiful thing. Singapore is so open about this, where basically I think foreign lawyers can in fact appear before an arbitral tribunal in an SIAC together. Whether they have or they don't have a Singapore lawyer, it doesn't matter actually, to in fact put forward the case either for the claimant or the respondent. So foreign lawyers in that sense are allowed to appear before an arbitral tribunal, which is conducting an arbitration. But she's absolutely correct in relation to courts. No. I mean, there are a lot of lawyers here, because what is happening here is this. Most of these foreign law firms here will also employ certain number of Singapore qualified lawyers, where so that if they have a matter in court, they can actually have these people who are qualified and admitted to the Singapore bar to be able to present the case. In the event, like say example, they need to go there to sort of, there's something, let's say there's something to do with interim measures or whatever, some other kind of aspects that needs a court's help, so to speak, even in the course of an arbitration, so to speak. So that's where these people come in. Otherwise, basically, it's all, in a sense, each jurisdiction protects its own sort of people, so to speak, right? I mean, you have to be qualified. And the other thing is also I do not know whether Thailand has this concept, but like in Singapore, you're admitted to the bar, right? So there's an admission to the bar thing, just like in Malaysia, and that I think also in Hong Kong. So that's basically a common law system. Yeah. So that's about it.
Thank you very much, Mr. Aziz and Dr. Vanina. We have one question for Mr. Swar. The question is, how can we learn more about ESG dispute resolution as it was spoken while our introduction?
So Mr. Djamel has already talked about the ESG ADR forum, which he was part of recently. So I think ESG landscape is evolving, and companies around the globe is of course focusing on to reduce their carbon footprint. And yes, of course, recently has been ERP framework has been produced by Indian government, where extending producing responsibility EPR is being implemented by Indian government, where all the companies responsible for ESG compliance is all the vendors of that particular companies under ESG will also be liable to have the ESG frameworks to be implemented in the production or the service facility. So when it comes to the concepts of ESG, yes, of course, you need to understand the very principles of the environment, social, and the governance part, and how is it focusing on the ADR? Yes, of course, in the ADR field, various international bodies are thinking to expedite the ESG proceedings in order to cater the environment events or environment questions that we have. So I think that's something which one of my expert can talk about. ESG is something which is very much booming, and I believe all the countries are in the race to advance the ESG reforms in their particular jurisdictions.
I would request Mr. Djamel if he could share his insights on the question.
Yeah, sure. Thank you for allowing me to talk about it because this is indeed a current topic. I think you have two way to look at it. ADR as a mean to resolve ESG disputes. So disputes related to environment, social or governance or all of that in the financial sector or in other sectors. But you have also another way to look at it is how you can integrate the ESG principles into ADR. So it's not only about talking about reducing carbon footprint of arbitration or such matter, which are also really important. It's not only about reducing plastic bottles in ADR centers, but it also applying concepts or principles to ESG principles to ADR, especially sustainability and long term, because we discuss about mediation often to justify the fact that it is a better process in order to keep a long term relationship between parties. So using such a concept of sustainability in ADR is also moving toward such common objectives. So, for example, to be more concrete, for example, during the ESG ADR forum, we have screened several companies here in Malaysia and assessed their ADR process, whether internal or external. So internal with their internal stakeholders, so their employees, how they consider how they put in place grievance mechanism or dispute resolution mechanism within their own stakeholders, with their own stakeholders, and also with their external stakeholders, such as purchaser or contractors. And we assess also especially the concept of how they handle the sustainability or the transparency also and accountability of promoting specific dispute prevention and resolution with such stakeholders. So it will be interesting to see within the next months or next years how we will be able to develop together with other regional centers and practitioners in ADR fields the ESG in ADR guidelines.
Thank you very much, Mr. Djamel. With this, we conclude our session. As we wrap up our today's webinar, I'd like to extend a heartful thank you to all our esteemed speakers for sharing their expertise and knowledge with us. Your insights have provided clarity on how to navigate the complexity of dispute resolution across the borders, which ensures fair and effective solutions. I extend my heartfelt gratitude to our incredible speakers the dedicated backend team, and the unwavering support of Miss Alex. Your invaluable assistance has been instrumental in making this event a success, and to our supporters. Of course, a very big thank you to all our attendees whose attendance has made this webinar a true success. We hope you found today's discussion informative and look forward to seeing you at all our future events. You can join our upcoming webinar on January 18th, 2025, titled as Leveraging the IFSC's Framework for Aircraft and Ship Leasing in India, India's IFSC. For staying updated for our future events, you can join our WhatsApp group, which is provided in the Q&A sessions. Thank you so much. Thank you, speakers, for joining us for today's webinar. Thank you, Miss Alex.
Thank you all. Thank you all for your time and the insights that you shared for the webinar.
Thank you.